Good morning and welcome to the PIRMA Third Thursday webinar series. My name is Kim Moretti and I am the Township Manager in East Pikeland Township, Chester County, and I currently serve as the Chair on the PIRMA Board of Directors. Thank you for joining us today for our program titled In the Line of Fire, Best Practices in Police Department Management. It will be presented by our popular tag team duo of Chris Gerber and Andy Rongas from Siena Law. Just a reminder that PIRMA now offers the PIRMA Legal Access Program, where all members are eligible for up to 120 minutes of free legal consultation annually on a wide range of matters. This may include a question about a right-to-know request, a personnel issue, a zoning or land use matter, or any legal question that needs a quick but thorough answer. More information about the new Legal Access Program can be found on our website at PIRMA.org. Watch your email for PIRMA e-blasts that announce additional educational opportunities, information on the Loss Control Grant Program, and resources that can be found in the PIRMA Resource Library on the new PIRMA website. You will also find recordings of our past Third Thursday programs under the Seminars tab in the Resource Library. Join us next month on March 21st for the PIRMA Third Thursday program, where we will have a replay of the popular topic Workplace Investigations. We are now in our fourth year of this program and are always looking for new topics that would be helpful to PIRMA members. If you have any ideas, please feel free to send an email to your account manager at H.A. Thompson. These programs are great educational opportunities for staff, police administrators, and elected officials. And now I'm going to turn the program over to Chris and Andy.
Thank you very much, Kim.
Go ahead, Chris.
Yeah, thank you very much. Thank you, Kim. Thank you, PIRMA, for another opportunity to address a topic that never gets old and needs to be refreshed really all the time regarding police management. It is my privilege to be here. Just by way of brief background, I've been practicing law here in Pennsylvania for the past 29 years, representing police officers and local elected officials in civil rights litigation, labor disputes, and employment matters. Over the years, I transformed my practice really from litigation into serving as special counsel and labor attorneys for municipalities dealing with police matters. It's my privilege to work with my colleague, Andy Rongas, who will introduce himself soon, but we put together a heck of a program for you. I would just make a point. As Kim mentioned, the PIRMA Legal Access Program is excellent. It's there for municipal officials to consult with lawyers for up to 2 hours on these issues. So I would not hesitate if you have any further questions regarding the subject matter that we covered today. Andy and I cover an ambitious amount of information, but I would also recommend that this is the type of program that gets you more than CLE credit. I think that the best recommendation here, and this is not legal advice, but to go back, whether you're in police command, whether you're an elected official or a solicitor, to take this information back with your municipal officials and have a meeting to determine where you stand on whether you're running a constitutional police department. God bless.
Thank you.
Again, these issues are at the forefront all the time, and it's my pleasure to bring them to you with my colleague, Andy.
Yes, thank you. Good morning. Good morning, everyone. Once again, thank you for having us. My experience is a little bit different from Chris's. I bring a different flavor to the table. I was a prosecutor for about 15 years with the district attorney's office, then went to the attorney general's office and became chief deputy attorney general. After that, I went to the Pennsylvania State Police and was deputy chief counsel for the state police before coming here to Siena Law, where I'm a partner and handle labor and employment, as well as representing criminal defense of civil rights alleged violations for law enforcement officers and government officials, police policies and investigations. So with that, we do have to jump in. Before we do it, Chris already mentioned it about legal advice, but I have to give you our disclaimer. This is not legal advice. There is no attorney-client privilege that's created here. This is just some lawyers who have done this work for many, many years and we're giving you our experiences for you to take back and try to implement, if necessary, into your municipalities. So with that being said, we're going to jump right in. Chris, internal affairs investigations are near and dear to your heart. So why don't you start us off?
Sure. I think that when we give these programs, Andy and I always ask ourselves, where do we start? Whether you are a freshman elected official or a veteran elected official or a new chief or been around, I think that the best way to approach this type of a program is to start with internal affairs. Because once we go through all of the parameters surrounding how a municipality is obligated to and conducts an internal affairs investigation into allegations of police misconduct or neglect, this implicates all of the roles of the respected officials. One thing that Andy and I can consistently see around the state is a troubling disconnect between the governing body, the elected body, which is ultimately responsible for the police department, and the police department itself. And oftentimes, due to nobody's fault, other than lack of information and a lack of understanding of the law, which here in Pennsylvania, unfortunately, is a patchwork of statutes and cases that really don't offer you in municipalities the easy answer on how to manage your police department. You have conflicting codes, conflicting rules out there that cause tremendous confusion. And then when you add in political rancor and animosity and agendas, it just becomes a political mess. Would you agree, Andy?
I would, and that's exactly it. As municipal elected officials, you hire a chief of police and command staff to be your experts in the line of when it comes to police department operations, etc. But unfortunately, with the way that police departments are set up in Pennsylvania, the chief of police and command staff doesn't just have to be in charge of policing. There's other functions that they have to do. They automatically become the human resources manager. They become a labor and an employment official, and they become a public relations official. So there's all these different things that come into play that are outside the scope of just actually policing. And I think, Chris, you're exactly right. When it comes to the biggest problem that we see when it comes to the management of the police department is not the scheduling of the officers or police operations. The chief and command staff have that under control. It's these other things that come up: human resources issues, internal affairs issues, things like that. And that internal affairs policy and investigations, knowing your roles of all the different players in it, is so important. And I think you're right. This gives us the opportunity to lay out exactly the internal affairs policy and the steps to take it that can then be used for other operations in the department and the municipality. So if we move on, jumping to that, Chris, you have the internal affairs policy. I think that we can certainly provide if anyone needs to take a look at it.
Yes, we are going to provide. And by the way, I need to stress this too. You certainly have the PIRMA legal access line. You can send emails directly to me and Andy. We'd be happy to provide our sample internal affairs policy, which, by the way, everybody should know this. This is not just coming from lawyers. Andy and I do not create a lot of this. We have over the years worked with law enforcement professionals. We've worked with police chiefs to craft an internal affairs policy that we think covers all of the global issues concerning all of the roles. And we're going to get under the hood in a minute. But you can definitely send me or Andy an email, and we'd be happy to send our sample internal affairs policy over to you. In 90 minutes, there's no way we're going to have time to get through that entire policy. That's not the point of the program. The point of the program is really to take the information that you have today and go back with your professionals and see where you are in terms of assessing your police department. So what Andy has brought up here, I'll take this screen, Andy, you can take the next.
Sure.
The internal affairs procedures, these are the fundamental parts of an internal affairs policy. We put number one, protecting the target officer's due process rights. The officer who's in trouble, we put that at the forefront. Why? If you've seen those articles about 100 officers in Philadelphia getting fired and 100 officers getting reinstated by arbitrators, Andy and I are pretty sure that a lot of that has to do with violating the police officers' due process rights. Would you agree with that, Andy?
Absolutely. I mean, it's important not only to protect the officers' due process rights for that reason, but also it's important to make sure that we protect those rights so that we have the ability to make sure that if we have an officer that needs to have some type of discipline that's imposed, that discipline sticks. And if we miss that opportunity and we make a misstep there, then, you know, we're going to exactly have an officer who's going to be put back by an arbitrator. And then we lose the whole issue when it comes to having the public having faith in your police department when, you know, there are a few bad apples that may spoil the bunch for the rest. So that's why we need to make sure not only are we protecting the target officer's due process rights to make sure that they are given a fair shake, but also to ensure the integrity of the process and the discipline itself.
Absolutely. And it gives credibility to the process also with the officers who are probably in a police association, a union. This is something that they need to understand and also have buy-in as well. All officers need to feel comfortable that they are going to have a fair shake. And one thing I've seen over the years, Andy, I bet you have too, is that there is this division between the police union and management over this issue. That shouldn't be the case. It should be a combined effort and a mutual agreement that a fair internal affairs process is good for all. What I've seen is over the years, good cops don't like bad cops. And we want to make sure that everybody gets a fair shake. So that's really one of the things that we stress upon when we meet with individual municipalities. And we do that, by the way. We come out and we train individual municipal police departments and their officials on how to do this. Don't exclude the union. Don't exclude the rank and file police officers. They have to have buy-in here. So that's why that's very important. And just to skip ahead to the next, but of course you need a full and impartial investigation. We're going to talk about retention of and tracking of complaints. We'll talk a little bit about methods of the investigation and then how to reach the outcome.
Exactly. And one of the things that when we start off, obviously the beginning of any internal affairs investigation is going to be the complaint itself. So that's where we're going to start. And you would be surprised, Chris, I know we've talked about this. Matter of fact, we just had a discussion about this yesterday on a case, and I'll get into that in a little bit. But the sources of the complaints, it's not just the person that comes in and fills out the form where the complaint can come from. Obviously, complaints may come from other police officers, may come from other municipal officials, public works officials, elected officials, other employees of the municipality. They may come from the public. All of those all of those complaints need to be addressed and investigated, because of the fact that not only is it the right and proper thing to do for your internal affairs policy in order to ensure that public trust and credibility amongst employees and the public, but also we have this thing now called Act 57. And Act 57 requires that any complaints that come in regarding a police officer have to be tracked and recorded. And the outcome of the investigation also has to be recorded. So that's important. One of the things that troubles me that we see even today in Pennsylvania when we look at departments is we talk about complaints, and we see that a lot of times in the collective bargaining agreement, it's been bargained for with management that the department will not investigate any anonymous complaints. And the theory behind that is just that, hey, if you're going to come in and make a complaint against an officer, then you know what? You got to put pen to paper, and you need to be willing to sign the paperwork on that. And I get it, and I understand why that's there. But in 2024, in the world that we live in, that can't happen anymore. You want to talk about not investigating anonymous complaints? You might remember a guy from Penn State by the name of Jerry Sandusky. That started out as anonymous complaints that the university didn't look at. So do you really want to find yourself, on CNN? At the state police, when I was there, we had anonymous complaints about sexual misconduct from a trooper that went kind of under the rug until, lo and behold, we find out that this guy really is a sexual predator. Think about what that will do for your department and the public trust. The other thing that we talk about, and one of the things that we hear a lot back, Chris, I know that we've talked about this. The one yesterday is we have a complaint that's come in against the chief of police in a department. Well, obviously, the chief of police can't investigate his own complaint. So where does it go? It goes to the township manager. And the gentleman who is making the complaint, for lack of a better term, is a bit of a wackadoodle. He's one of those guys that just complains about everything, and it's there's really nothing to it. So the township manager asks, well, do I really need to meet with this guy? And I get it, we're all busy, but the answer is yes. You have to treat his complaint just like you would treat everybody else's. Because how does that look when you get called on the carpet with that? Well, I didn't talk to that guy because he's crazy. Well, you don't even know what the complaint is yet. What if the complaint is something very serious? The blind squirrel that finds the nut every once in a while. So we have to take a look at that. Any type of complaint, whether it be anonymous, whether it be oral, whether it be written and signed, should be investigated. And then where we come into this is that the type of investigation depends upon the type of complaint and how that it's made. We're not going to be doing the Lindbergh investigation on an anonymous complaint unless it's warranted, but it needs to be addressed. Would you agree with that, Chris?
Absolutely. Yeah, you can't turn away just because it happens to be anonymous, right?
All right. So records of complaints. Chris, why don't you take records of complaints?
Sure. In this digital age, you got to find a way to ensure that you are retaining these complaints. Andy made a good point about Act 57. You've got to keep a record of this by law now, so that you can determine whether we have a pattern of problems with the police department, whether we need additional training in a particular area. Are these complaints involving use of force, alleged false arrests, anything from rude behavior, whatever? This record needs to be made so that we can quantify whether we have a pattern of issues that need to be addressed. So I know there are many, many different ways to do this. You've got all kinds of vendors out there selling products on how to do it. I'm kind of in the Stone Age on this. I like the paper file, Andy. I think that you can certainly maintain a paper file, but if there's an electronic database that can do it, that's all right too.
That's it. It just needs to be obviously complainant, type of complaint, assign a number, and final disposition, so that we be able to keep track of that for Act 57 purposes, as well as, if, as Chris said, that to be able to show whether or not there's some type of pattern. And why is that important? Well, it's important because in the civil rights realm, there's a theory of a civil rights complaint called a Monell claim, which is a claim that is brought against the municipality for a failure to train, failure to discipline, or failure to properly hire or screen. And one of the ways that we protect against complaints of Monell is by showing that the department has a proper internal affairs policy, which is acted on correctly. And if it comes up, for example, to show whether or not this officer may or may not have a pattern of doing something, like, for example, high-speed pursuits or excessive force or something like that, we'll be able to show, no, he doesn't have any type of being able to do that on a consistent basis, because here's our internal affairs complaint policy tracking system, and we can show that the public no one has ever made a complaint like this before. It's very important. All right. Chris, due process rights of the officers. We kind of talked about this a little bit, but why don't you give us a little bit of a deeper dive on it?
So the 30-second thumbnail sketch on this is, generally speaking, police officers here in Pennsylvania, if they're full-time or members of unions, or they're covered under statute, they have a right to know what the charges are against them with an opportunity to present their side first before adverse action is taken. That's key. I think later on we'll talk about the Loudermill decision, but essentially, police officers here in Pennsylvania have a right under the 14th Amendment of the United States Constitution to be on notice of potential administrative charges, a brief statement of evidence against them, with an opportunity to respond. Believe it or not, Andy, as we have seen, sometimes a police officer alleged to have done very bad things might have an answer, may have a defense up front. So it's very important to conduct the process to allow that officer to present his or her side before the municipality terminates, suspends, or demotes that officer.
And Chris, one of the things that we get questions on a lot about this is, when do we have to notify the officer of the investigation, and when do we have to give him or her this opportunity to present, their side of it? And I think that there's no one size fits all answer to it, but do you have a general thought on that as to where you try to lean in one way or the other?
Yeah, that's a great question. My immediate impulse is sooner than later. I think that because remember, we represent police officers as well as municipalities. And if I were representing the cop, I'd want my officer to know immediately in the event a complaint is filed against him or her out of fairness. You should not hide it from the officer. What gets complex, and I think we're going to talk about it today if we get to it, what does get complex is if there is a suspicion of criminal conduct. And this is where, Andy, thank you for your help in working with district attorneys and the Attorney General's office. Every once in a while, the conduct of the officer could rise to the level of criminal behavior. If a law enforcement agency is investigating one of our officers in our municipalities, sometimes we've been requested by law enforcement to hold off on advising them because we're just being told by the DA, right, Andy? Do you kind of want to jump in there a little bit?
Sure. Yeah. No. Absolutely. This is exactly right. So here's what happens, and we're going to talk about it. We're going to talk about it in a minute, but we'll get there right now. So a complaint comes into the department, and the chief or whoever in the command staff is taking a look at the complaint. And one of the things that they're going to need to do first and foremost is they're going to need to decide whether or not the complaint could rise to the level of criminal activity. And if, based upon their police experience, looks like that it could rise to the level of criminal activity, then what we suggest and what is proper best practice is to then reach out to the district attorney's office and say, hey, listen, this is the complaint that came in. This is what the allegation is. What do you want us to do? And the DA then is going to do a couple things. They're then going to take a look at it. They're going to make a decision as to whether or not they want to investigate it on a criminal matter. And if they do, then that will put our internal affairs investigation on hold until the decision has been made in the criminal case for a multitude of reasons. Number one, and the most important one being that we don't want to do anything in our internal affairs investigation that would either jeopardize the ability of the district attorney to bring criminal charges if warranted, or we don't want to do anything in our internal affairs investigation that would in any way hurt the officer regarding their potential defenses in a criminal case. So once that decision is made, then we can move forward with our internal affairs investigation. And I will tell you that municipal elected officials, that is one of the hardest things for them to be able to do, because as we all know, criminal investigations, depending upon the the scope and the potential charges, take some time. And elected officials don't want to hear that. They're like, well, wait a minute. Why haven't we proceeded with our internal affairs investigation and either moved on to putting this officer back on the street, or they're kind of in limbo. So it's an important thing that we need to look at. But all of that is in the idea of protecting the due process rights of the officer, because if it's a non-criminal investigation where you're going to impose some type of discipline, the first thing when this case goes to arbitration is going to be that arbitrator is going to go down their checklist of 9 things to make sure that due process rights were checked. And if they weren't, then you're probably going to get a adverse decision from the management side.
Let me pick up on that. Everything that my colleague just said ought to be reiterated in a meeting. This is what we suggest when we're training elected officials on how all of this works. We have an executive session to discuss legal matters, in particular, your new internal affairs policy. We whiteboard this situation and bring up exactly that scenario.
Hey, Chris, let's go to the next slide because this is exactly it.
All right, perfect.
Go ahead.
All right. Yeah, this is perfect. So everybody, this is taken from our sample internal affairs policy. This is probably the heart and lungs of the theme of the policy, because this ruffles everybody's feathers. Chiefs get upset when they hear that I have to tell everything to the board before I can take any type of administrative disciplinary action. That's a myth. Elected officials get upset because they think they should know every single thing that is going on in the police department. That's a myth too. What we try to do with our policy is to strike the appropriate balance that will achieve the appropriate division of roles between police department personnel and the elected officials. Now, I'm going to read this and we're going to try to go through it and give you a concrete example of how this works. So in the event a complaint against an officer contains allegations of a crime, workplace harassment, or where the complaint contains allegations which could, if proven true. This doesn't mean that we have absolute proof that the cop did it, but if proven, it could lead to the officer's discharge, suspension, or demotion. This now triggers the obligation of the chief of police to bring this to the attention of the governing body. Yes, we've heard many times, Andy and I, all over the state, we've heard some solicitors give the advice that the governing body should know nothing about this until after the chief conducts the internal affairs investigation. That's flat wrong. That's going to get you into trouble. Andy mentioned the Monell theory of liability. The governing body needs to make sure that the police department is conducting appropriate internal affairs investigations. The only way they can know that is that a complaint has been made. So this is really the launch pad of the internal affairs investigation, that the chief needs to get into executive session to alert them of the complaint. And by the way, as Andy said earlier, this is not minor infractions. Everybody, this is not the scratch of the car or late for work. These are the real bad ones, right, Andy? These are the real egregious claims.
Absolutely, yeah. The board doesn't need to know that, the car wasn't parked in the right spot, or that there was damage done to the vehicle, in a minor, I don't even want to say accident, but scratch to the door, or the officer was late, or there's some type of report issues, or anything like that. This is the serious stuff that we're talking about. Exactly.
That's right. That's right. And here's the next thing. And I think we probably have in the next slides. Forgive me, I probably get ahead of myself. But we're going to get to the criminal activity. But one of the points everybody should take from this is, once the chief alerts the board of the complaint and the chief of police has no conflict of interest to conduct the investigation, once everybody's comfortable that the chief is not the alleged culprit or the cousin of the culprit, whatever, that there's no conflict, the chief then coordinates and conducts the investigation. In the more complex ones, of course, we recommend that your labor attorney is in on it to ensure that all the T's are crossed and all the I's are dotted. However, the elected officials need to know this: you do not get involved in the investigation. Otherwise, you could be violating the target officer's civil rights. Why? Because members of the elected body are the adjudicators, the judge, right, Andy?
Yep.
They sit in judgment. So therefore, they are not to be getting into the investigation, because they can't serve as investigator and as judge. We'll get into that probably a little bit.
Yep.
All right, our next slide, we could probably blow through this. We talked about
the criminal activity. Yeah. We talked about this already. You need to notify the DA. Everything needs to get put on hold. until the DA gives you the up or down as to whether or not a criminal investigation is going to take place. So that one's a pretty easy one. We've already talked about that. So then we move on to procedure for investigating the complaints. And Chris kind of mentioned this to start, is one of the reasons that we need to let the governing body know of these very serious type of offenses, where, as we said, a crime, a workplace harassment complaint, or anything where it could result in termination, suspension, and or demotion, is because one of the things that the board needs to then decide is who is going to do the investigation. And Chris mentioned one of the considerations that they need to take into consideration is just that. Is the complaint involve the chief? Is the chief either whom the complaint is made against? Is the chief potentially a witness to the complaint, to the issues? Those would be questions that need to come up to determine whether or not that there's a conflict of interest. Also, another thing that we see a lot, especially with our smaller departments, are, do you have someone who has the ability to do an internal affairs investigation? Do they have the proper training? Again, do they have a conflict? If you have a 5-person department where, the detective who's going to be the one who does the investigations was the best man at this guy's wedding, then, again, we're talking about potential conflicts there. So who should be doing it? Should it be someone inside the department, or does the department need to go to an outside investigator? And Chris, what type of outside investigators are we talking about here?
Andy knows that's straight to my heart. I'm going to recommend that if it goes outside the department, that it's assigned to a lawyer. Oh my gosh, if there's any chiefs on this right now, they're just going to lose it. It's very important. We have seen investigations handled by outside non-lawyer investigators. They become a complete train wreck. There's no attorney-client privilege. Oftentimes there is a question over the scope of the investigation. Costs get out of control. And I just haven't seen an internal affairs investigation handled exclusively by a private investigator that went well. I'm sorry, Andy, you might have different views.
No, I agree. I think that some people are probably laughing when we talk about that lawyers don't let costs get out of hand. But
no, that's okay if the lawyers are charging. But
sure, yeah.
But
no,
in all seriousness, I'll let you certainly give your view. The positive side of having a lawyer do it is that the lawyer will be acting as a lawyer, meaning that you're going to retain attorney-client privilege. Your report is not issued to anybody but the governing body and anybody in that inner circle. That has been upheld by law. Andy, what's your view?
I'm in agreement with that, but I take more of a kind of a dual approach. I think you should have, if you're going to go with an outside investigator, you should have the attorney who is going to be in charge of it for just that reason, like Chris said, is that it's then covered under the attorney-client privilege. And we don't have to turn over the report in future investigations or matters. So, for example, in that case, you use an outside investigator who's a non-lawyer. They do this investigation, and then there's a lawsuit that comes down the pike from somebody, either the person who makes the complaint or from the officer themselves or whatever it is. Unless you have that attorney who is doing it, the investigation is not cloaked in the attorney-client privilege. It's not confidential. And then you're basically taking all of that work product and turning it over directly to the other side. So that's why I think it's important to have it done by the attorney. But also, I like to take that dual role. I think there should also be an investigator, whether it be an officer from the department who is in it, or a private investigator, or somebody to be the actual investigator. And why do I say that's important? Well, Chris, we've had this conversation 1,000 times. If I, as the attorney investigator, go in to take a statement from someone, I have now become a witness to that statement. So if there's a question that comes up regarding something that happened in that statement, unless there is a stenographically recorded interview, then I then have to take off my prosecutor hat and then put on my witness hat, which is no bueno. So if we have that officer there with me, just even if I'm conducting the oral interview of the complainant, I've had a lieutenant or another officer sit in front of me so that if in the future during a arbitration I need to call a witness, I have a witness that I can call.
Yeah, you and I part ways on this, definitely. And now we're talking about the nasty ones right now, right, Andy? We're
Oh
talking
yeah,
about
no, this is not. This is not the officer was rude to me.
no.
Or a complaint about service. I mean, these are your crimes, your workplace investigation, and or the really serious stuff. Exactly.
Yeah. Hot pursuits ending in serious injury or death, use of force ending in injury, theft, things like that, deceit. Unfortunately, our office has dealt with a number of claims that the officer has falsified a record or falsified a report. These are the things that really, I think, need the advice of an attorney on. Just in my experience, I don't have a problem being the investigator and ultimately the prosecutor. I ensure that I get the authority from the municipality up front to stenographically record my interviews. And therefore, I'll turn those interviews over to the union in the event disciplinary action is taken against the officer. We have a much different approach, by the way, than the other law firms out there. They do it differently. I actually see, Andy, some law firms will assign 2 lawyers, and now they're double billing the file. They'll have one lawyer in charge of the investigation and then use another lawyer to go in and conduct the interviews and use that lawyer as a witness in arbitration. That's insane in my view. I don't think that's how you do it. I like your idea of potentially having a private investigator retained by the law firm, which you can then retain attorney-client privilege with that private investigator and have that investigator conduct interviews. That can be appropriate under certain circumstances. But let me come back just for a minute because we're really getting into the weeds on this material. I can't emphasize enough that those on the line today who obviously have police departments, you've got to schedule that meeting to get into that boardroom to go through a couple of scenarios from complaint to outcome with your board, with your chief, your labor attorney, and your internal affairs policy so that everybody understands. This should be done on a yearly basis, in my view, especially now that new municipal officials have been elected and have never seen policy number 1. You got to get them in there and make sure they understand. Andy made a good point. Are you ready for CNN to drop into your town at 2 a.m. when there's been a shooting and one of your officers kills somebody? Are you ready to answer those questions? And I'm willing to bet not. So again, this program is not just for fun or interest, but rather to use proactively to educate your officials.
All right, so we've talked about this again. We need to make sure that the townships the municipalities administrative internal affairs investigation is conducted separately from the criminal investigation, and in 99.9% of the time, your internal administrative investigation is going to be placed on hold pending the criminal investigation. I have seen some instances where there is other conduct that is not related to the criminal investigation. Maybe maybe you want to move on that, but those instances are rare. And I suggest that if you're doing that, you're going to do that, that you not only consult with the district attorney's office, but also your labor counsel or solicitor in order to make sure that everything is copacetic with that plan.
And by the way, ladies and gentlemen, I got to plug one for Andy Rongus, who knows everybody and their grandmother in law enforcement, where he's got a cell phone connection to all the players. That's very helpful when something like this hits the fan and there's some sort of criminal conduct going on. It's very important and helpful for your lawyer, your labor lawyer, like Andy Rongus, to be able to have that direct connection to law enforcement. Because listen, in this age of text messages and emails and all the different ways that we communicate, Andy, there is no substitute for the phone. Am I right?
No, you're right there, but I appreciate the plug, but unsolicited, I swear. All right, so the process of the investigation, this is where we kind of get into obviously the nuts and bolts, or as Chris has said, down into the weeds. We're going to try not to get into that, regarding investigative steps and everything like that, especially when you're going to have an investigator who is been trained not only in doing investigations, but also internal affairs. But one of the things, and I feel silly for saying this, but we have all these examples that we've given you are real life examples. So I can't take for granted that maybe, we have to say this kind of stuff. But one of the things that we've seen where there's a problem is we have the investigation being conducted by a member of the department who is a lower rank than the officer being investigated. And why is that a problem? Well, that's a problem because we have seen just that, where the investigator makes findings to the chief of police for disciplinary procedures, and then the train runs off the track. And how does that happen? Well, that happens because the officer who's being investigated, who is the superior officer, is going to say that the investigation was tainted because that officer doesn't like him or her because of the way that they've supervised them, or the fact that they've taken disciplinary action against them previously, or whatever. Or the flip side of that coin is the investigation is going to be completed, discipline is then going to be imposed, and the officer who did the investigation, who's of the lower rank, is then going to get jammed up. And then they're going to say that, well, the only reason that I'm getting jammed up is because I conducted the investigation against this, my superior officer, and now they are retaliating against me. So it's a bad situation all the way around. Also, one of those reasons why, maybe you look to having somebody else, if you have a smaller department and you have a very serious workplace investigation that needs to be completed. All right, we keep harping about due process. And this is kind of where we get into that Loudermill, as well as some of the other rights that the officer may have. Chris, why don't you take us through some due process concerns that we see and where some of those missteps are?
Sure. So we already talked about what's called the Loudermill rights, and that is the notice of the charges before you can take action against him. But officers also have a labor law right under the Weingarten decision to have a union representative with him or her anytime, and this is to be construed liberally, anytime the police officer, and I think this is a subjective standard, Andy, anytime the police officer is brought in for questioning or an administrative interview by the chief or some other investigator, and they think that they're going to get in trouble, I would recommend that you stop it if they ask to have a Weingarten rep with them. And believe it or not, the Weingarten representative could be a lawyer under certain circumstances. Now, I will generally give this recommendation that if you want to bring in a police officer for an administrative interview and he wants to bring his lawyer, that is not permitted under those circumstances where the chief is going to interview the officer and the officer says, I'm bringing in my private lawyer. He is not entitled to that. There are some exceptions. In the event the police association were to authorize a lawyer to serve as a Weingarten representative, that is permissible. However, when that lawyer sits in on that interview, the lawyer can't act like a lawyer. Right, Andy?
Yep.
He has to essentially be there as any other non-lawyer Weingarten rep, and they can be there to perhaps help with a question or counsel the officer. I give them great leeway. By the way, I don't have a problem when I do the administrative interview. First, that's an exception to the lawyer rule. I take the view, I'd like to hear from you, Andy. I take the view that anytime I interview a person who's represented by a lawyer, I think the rules of professional conduct obligate me to allow a lawyer to be with him. I don't think you can exclude the lawyer under those circumstances.
I'd agree with that. I think it's best practice when I like having lawyer. That way it doesn't look like I'm taking advantage of anybody or there's, any type of taint or anything like that. They're there. And quite frankly, for the most part, I found that when we do it that way, that the lawyer is actually helpful to moving the process along, to getting to the nuts and bolts as to, what the issues are and to get the answers out there. which I think I found to be helpful. It's when you get either a lawyer or a wine garden representative from the union who wants to somehow try to stonewall or prevent your investigation from moving forward. That's when I think you get into this rub, and that's where I think the wine garden actual rights and limitations come into play. And specifically, those rights and limitations are just that. It's the individual officer's right to be able to either request a wine garden representative or to ask questions or counsel from the wine garden representative. So in other words, it's not proper, and I'm not saying that I do this. I give a very open leeway. But if you want to take a look at the letter of the wine garden decision and the way that it's been interpreted, it is the officer's request. So I've had investigations where the chief is doing an investigation, or the lieutenant's doing an investigation, and we're talking about it as labor counsel. And I'm bringing the officer in, on Monday. I said, hey, if you had a wine garden, they're going to have a wine garden rep. Well, hey, that's their ability to ask. I'm not offering it. And it's like, well, wait a minute. Why not? Why aren't you offering it? Why wouldn't you put that out there and let them know about it? So, it is their right. Or I've had wine garden representatives interrupt the questioning by saying, hey, listen, I'd like to take a break and talk to Officer so-and-so. Technically, under the rules, that's not appropriate, but I have never stopped somebody from doing that. That's just the way that these work that I find in my experience. Let you get to the meat of the matter and allow it to be a productive conversation.
I'd like to pick up on that just a little bit on the wine garden rep, either being a member of the union, police officer, or as a lawyer. We've seen situations where that wine garden rep officer attempts to interfere with the interview. The way I've learned to handle it, and I've done this the wrong way, Andy, is engaging in an argument with the wine garden rep. That is not the way to do it. The way to properly do it is to almost ignore the wine garden rep who's interfering with you and simply speaking directly to the target officer and advise him that in the event the officer does not cooperate in the interview, he could be disciplined for it. And I continue to remind him in my role, I have no authority to direct him to do anything or not to, but in the event that officer, on the advice of the wine garden rep or whatever, doesn't cooperate, he could face discipline. And oftentimes that leads to a break. You take a walk down the hall with the wine garden rep, you cool it down, and believe it or not, they come back and they cooperate. That's how you defuse that very, very quickly. The other issue, when the lawyer is attempting to interfere, I'll do the same thing. I'll take a break and I'll take a walk down the hallway with the lawyer. One thing I have learned over the years, when you do these administrative interviews as a lawyer, a labor lawyer, I continue to see a difference the way we approach it. We're not out to get the cop. That's not the point of the interview. The point of the administrative interview, that's the first time you have the cop in to address a complaint. He's not on trial. You are not cross-examining him. You are there not in a leading fashion, but there in an open-ended forum to allow that officer to present his side. You're not out to get him. And I have seen, Andy, our competitors take that tack where they're essentially cross-examining the officer and turning it into an interrogation. I think that's improper, inappropriate, and unfair. Rather, we are there with the open door. We ask open-ended questions and allow that officer to answer and present his side, and we don't take an adversarial tone. I have seen other lawyers do that, and it automatically, starts the process off on the wrong foot, and now all of a sudden, the union and the officer become very, very defensive, and it could probably lead to unnecessary litigation. That's my view.
No, Chris, I think you're exactly right. And that goes back to the whole idea of understanding what everyone's role is at the situation. You're the investigator. You're not the prosecutor. The investigator's job is to develop what the facts are, to then present them to someone who is then going to make a decision, normally the chief, who's then going to make a recommendation to the elected officials as to what the appropriate outcome of the investigation should be. At that stage of the game, as a fact finder, it should never be adversarial. And you're right. I think that's where we see a lot of unnecessary litigation, because one side or the other makes it adversarial when it doesn't have to be. And that ties right into what we're talking about, is the roles of the investigation. And this is exactly right where Chris says that we should get everybody, newly elected officials, our municipal managers, if we have one, our command staff, the chief of police, labor lawyer or solicitor, into a room to talk about what the specific roles are of the individuals, because this is where we see a lot of times the mistakes are made when it comes to these types of investigations. Specifically, the board or the elected officials are the fact finder and the penalty determining the penalty, and that's what their role should be. The investigator goes from being a fact finder to either providing those facts to the chief of police to be the one who becomes the prosecutor, or they can also serve as the prosecutor, so to speak, to the case itself. What's important here is, and this is where does the chief of police play its role in here? Well, they may be the investigator in the case, but they are also going to be the one who makes the determination to the board as to, number one, what the facts are, and number two, what the penalty is going to be. And this sometimes rubs the chief of police the wrong way. And we also see where it has a mistake which causes problems, is where the chief of police becomes judge and jury and executioner all in one. And that's a problem, especially when we have cases where the discipline to be imposed results in termination, suspension, or even termination. Obviously, we don't see it on termination that much, but I've had cases where there's a litigation that comes up where it's 6 months after, a year after everything takes place, and I'm going through the records and I'm looking at it. I'm talking to the chief, and I'm like, "Well, hey, chief, what was the outcome of the investigation? What was the penalty?" "Oh, he got the officer got a 2-week suspension. I put him on the bench for 2 weeks." "Okay, and when did the board approve that?" "The board didn't approve that. I suspended the guy for 2 weeks." And it's like, well, okay, but you can't do that. You don't have the authority to do that. "What do you mean I don't have the authority to do that? I'm the chief of police." Well, you are, but quite frankly, the way I look at it is, I would want the board to do it, because that gives me plausible deniability as the chief, right? So understanding what that role is, whatever penalty is imposed, it must be imposed by the board in a public meeting, approved in a public meeting. And I'm not talking about that we need to get down into the nuts and bolts of every gory detail of the event, Chris, right? How does it have to be approved in a public meeting by the board?
I move to suspend Officer Doe for a period of 2 days without pay. Second, discussion, all in favor? Aye. That's it. But it's got to be done. It's got to be done under the Sunshine Law. Don't get cute and say badge number 1, 2, 3, 4. I've seen some of our competitors do that. That's not advisable. You have to do it. It's ugly, but you got to do it. And Andy is right. No one but the governing body, that's boards of supervisors, boards of commissioners, councils. Cities can get a little different, but we're talking about local government, really from the townships to the second class, first class, and councils today. Only the governing body, by law, has the authority to terminate, suspend, or demote a police officer. There's no dispute on that. And I want to add a little bit to that, Andy. Yep. I have seen time and time again where either the chief will unilaterally do it, or what's worse, the board delegates that authority to the chief, which they don't have. Here's a horror story in 60 seconds. Chief of police I represented not too long ago, township of the first class. That board had authorized the chief to suspend officers for up to 5 days within his discretion. There was an allegation that a police officer under his command improperly used a taser and hurt somebody. I won't get into the gory details. Ugly allegations, racial claims, really a mess. The chief did the investigation. The chief suspended the officer who deployed the taser for 5 days. Then the board finds out about it, and the majority of the board, it was a mess because you had half the board liking the chief, half the board hating the chief, but a majority of the board found that the chief went too lenient on the officer. What did they do? They fired the chief. If they followed the law and followed our internal affairs policy, that would never have happened. That would never have happened because the information would have been provided to the board and only the board would have the authority to do it. So it was a political mess. It ended in a career of a very, very good chief who was not motivated by race. It was a bunch of nonsense. But if they had the appropriate internal affairs policy in place, that chief would still be there today.
Yep, that's exactly right. And that's exactly why we talk about right there the need and the ability to advise the board of any type of internal affairs investigation at the beginning of just what's there. I see we have a question that came in.
Oh, good.
What if the officer signs an agreement for a set suspension that was drafted by an attorney? So the answer to that would be that's fine. The officer can sign an agreement. It can be, you can come to an agreement as to whatever the penalty is going to be. The important part is going to be, though, that the board is the one who has to ultimately approve it for purposes of the penalty that's imposed. So if you want to work with the union on the side and, you know, and come to an agreement that, okay, this is what the officer is going to be found to have violated for policy purposes. This is what the recommended disciplinary action is going to be, and everybody's all in agreement. That's fine, and they can sign an agreement to that effect. It just ultimately it needs to be approved by the board, and it needs to be done in the light of day under the Sunshine Act, right, Chris?
Yes, I need to jump in on this.
Go,
That's
please.
great. Yeah, that's great. That's when everything ends up just fine. However, if you're going to negotiate, don't do it up front. We recommend that the process goes forward and you don't start negotiating what the cop will take before you do the investigation. You start doing that, you're going to lose traction, you're going to lose time, and you're going to lose leverage. So this is purely a management tool that it's okay to negotiate some sort of discipline, but follow the process first. Let it play out. Do your investigation appropriately. Put the officer on notice of potential charges. If the union or the officer and his lawyer want to make a deal, let them come to you. But this is, Andy, this is important. Don't wear the white hat, management, and think that you are, you know, this is kumbaya. I've seen too many times where chiefs get in trouble where they just want to go talk to the officer and would you take 3 days? Just be careful. Make sure that you are following the process first. Again, there's always room for negotiation, but you got to do the investigation up front.
All right, and so I think we've kind of talked about this as well. You know, there's case law that specifically indicates what we've talked about here, that the ultimate authority to impose discipline rests with the governing body. It can't be delegated to the chief of police, and quite frankly, it's not official until that's been done. Chris, you and I have had a case where officer gets terminated, but then find out that, you know, 6-8 months later wants to come back to the department, even though he agreed to a termination. And as we go through and look at things, we find out that the governing body never approved the termination proceedings. So then it's like, well, ruh-roh, now this guy's asking for back wages from the last 8 months because technically he's still been on the books. I mean, it was never officially done, right?
Yeah, very embarrassing, costly. You know, again, that's where, you know, it does get a little complex here because this is where the Sunshine Law, you know, doesn't jive very well with other statutes in this area. Then it really gets in another course that we can present too. you need to know too that there are federal rights that are available to the officer, but then also state law rights under the Police Tenure Act and the Borough Code that give the officer some additional protections as well. So solicitors, if you're on right now, be mindful of that. And this is where I think that you probably want to reach out in those nasty cases to Labor Council that have dealt with this before.
All right. So moving on, this kind of just talks about what we've already kind of said, is that the Board of Supervisors' role in police management, they have they can create or disband a police force. They also have the right for, to secure health, safety, and welfare of the citizens of the township. We don't need to delve into this, too important. But when we talk about a township or a borough manager, it's important that some rights can be delegated. I know that we've mentioned this, but it has to be a non-legislative power. And one of those powers that cannot be delegated is the right to discipline officers for purposes of termination, suspension, or demotion in rank.
Okay.
Board of Supervisors, the final policymaker. We've talked about that. Hiring and firing decisions, the impact of Act 57. This, again, we talked about it, but there's a couple important things that I think that we should go over with it. When it comes to Act 57, Chris, we could probably do a whole hour and a half on just Act 57 and its implications on police management itself. But just to keep that 30,000-foot view of it, Act 57 did a couple of things, especially when it comes to hiring. One of the most important things I think that it did is it now put into place a statutory minimum of background checks that need to be done when hiring a police officer. You take a look at the act itself, it tells you exactly the 8 or 9 enumerated things that need to be done. One of those things in there is that it needs to, you need to speak with employers for the last 5 years, and you also need to speak to employers for any law enforcement agency over the individual's career. So keep that in mind when you're checking that boxes when you're going through and doing the Act 57, hiring process. In addition, it requires, as we mentioned before, that there be a record of all complaints that are made against the officer, as well as the disciplinary outcome against the officer. And more importantly than that, there are what I like to call the 10 deadly sins that are included in Act 57, that if the officer has any of these things in their background, then the municipality has to fill out a form that gets filed with MOPEC and is public record under right to know, indicating that they were, number one, aware of these issues, and number two, decided to hire the officer anyway. And why is that important? Well, that's important when we go back to that civil rights case that we talked about, Monell. I know that hiring of police officers is a hard thing to do these days. Not a lot of people want to do it for obvious reasons in the world that we live in today. But if you don't check the boxes on this Act 57 stuff, and you hire, say, for example, an officer who has excessive force complaints in their background, and then you have an excessive force complaint or issue with that officer in your municipality, one of the first thing plaintiff's attorneys are going to do is they're going to go back to see what this officer's history is and see if you were aware of that history. And if you aren't, then I think that there is a potential cause of action against you, against the municipality under Act 57. So we need to make sure that all of those I's are dotted and T's are crossed. If you have specific questions under Act 57, you can use those 120 minutes with PIRMA to reach out and ask those questions, for the legal access program. Chris, anything on Act 57 that I missed?
No, you covered it, but I will add this from a practical standpoint. Most of those police departments we represent out there, between 7 and 10 police officers, oftentimes you don't have the time or resources to conduct that full Act 57 investigation. We know some very, very good private investigators whose consulting firms zero in on that, and they do that for you at really not a lot of cost. So it's something you might want to consider. It sounds like a commercial right now, Andy, but however, I got to tell you, there's a couple of private investigators that do an outstanding job for our clients, and you might want to consider that again if you don't have that resource in your department.
No, absolutely. I see, Chris, how it is. Private investigators are good enough for Act 57, just not internal affairs investigations. I
That's
see.
right, Andy.
Okay.
But we're gonna take a heat for this. I'll take
Yeah,
heat
we
for it.
are. So again, these are the cases that we talked about, the case law that makes it clear that the Board of Supervisors or the elected officials are the ones who have the responsibility of how all police officers should be disciplined. Santiago versus Warminster, chiefs of police, you're going to learn to love this case if you're ever sued, and this is exactly why we say that you should be the one who is not making the final decision. You can make all the recommendations as the expert in law enforcement and police department operations that you want to the board. And I would certainly hope that the board gives that, the proper weight when making the decisions. But case law specifically says that the chief of police or command staff are not final policymakers when it comes to police department operations. And that's good for you because that's our ability to get you out of the lawsuit very early on in the process.
Huge,
Chris, anything
huge.
on Santiago versus Warminster?
Yeah, just 30 seconds, Andy. When I first meet a chief of police and I advise him or her of that law, they get very, very mad at me until they realize that once the court finds they're not a final policymaker, they're out of the case. So we'll plug our internal affairs policy one more time. You follow this process, we'll get you out of the case, chief.
Yep, exactly. Okay. Let's go back to
that's a big one.
there. So, Chris, why don't you take this because I know that you're big on those binders on policy review, especially, and then very importantly, I joke about it, but very importantly, especially when we have newly elected officials, right?
That's right. So this is a slide you can take back. Chiefs are going to love us. And ask the chief, when was the last time these high risk critical operations were reviewed? And they should be able to tell you these need to be reviewed from time to time in conjunction with a civil rights or labor lawyer together with your chief law enforcement officer. These are the areas of police operations that statistically give rise to the most liability, hands down. I'm not going to read this entire slide. We're already running out of time, but this is definitely one you want to ask your chief. When was the last time these policies were reviewed by an attorney?
No, and we talk about that, and again, I can't tell you just how important it is in looking at this list. Pursuit and emergency vehicle operations. A lot of departments, a lot of the large departments have the financial ability to use the programs that keep updating the policies as case law and stuff comes out, and those are great. If you have the fiscal ability to do that, that's wonderful. I know there's a lot of departments, especially the smaller departments, that don't have the financial ability to do that. And even in Pennsylvania today, still, I kid you not, in 2024, I can go in on a civil rights lawsuit. And one of the first things that I need to do, especially when there's a Monell claim there, which there always is take a look at the applicable policies based upon that. I still have police departments who say, well, we don't have a policy and procedures manual. And it's just like, wow, how many zeros are we adding to this check that the insurance company is going to write? And then the ones that do have them are outdated and they haven't been updated, and that they should be updated. This is one of the things as a municipality that your elected officials need to be aware of, especially not only that they're updated and that they are there, but that the elected officials know what the policies are and have at least an understanding of the non-tactical or non-law enforcement specific operations of the policies. Because again, the last thing that I want is in a deposition having an elected official being questioned about the department's policies, and they say, "Oh, I've never seen those before." And it's like, wow, really? Go ahead, Chris.
We have a question.
Yep.
And it's perfect timing. So the question is being an accredited police department through PLEAC, which is the Pennsylvania Law Enforcement Accreditation Commission, does that help with reducing liability? The short answer, in my view, and Andy, I'll turn it over to you in a minute. The short answer, in my view, is absolutely. However, the caveat is it depends. That's the lawyer's answer. It depends on the particular case, because if one of the policies at issue, we're not up to snuff with current civil rights law, then it's not going to help you. But the bottom line is, I think it's very healthy to go through the accreditation process. It brings these matters to the forefront. But again, it may sound like I am plugging lawyers, but I don't know who's reviewing those policies for my police department. I know that different organizations out there will help you, like Lexipol and things like that. But the short answer is, Andy, I think it is healthy to become an accredited agency. What's your view?
Oh, absolutely. I mean, that raises the floor to at least, from a litigator's in civil rights cases, that at least raises the floor to at least I know that you have policies and procedures in place that are, the 90% chance of them being at least, correct in the sense of maybe there's something there that, hasn't been addressed with an update. The other thing that plea acts are great for, but where I think it needs to go hand in hand is for some of those policy considerations. For example, I'll give you the pursuit and emergency vehicle operations policy. So case Nescahoning versus Sowers, which came out where the Third Circuit in 2018 or 19 completely threw a wrench in the pursuits and how law enforcement can be held accountable for them. And they basically, the pendulum swung to the point where any type of high-speed pursuit where the officer is not pursuing the individual for a violent crime, then you potentially could be looking at liability there. Now, that is unsettled in the law right now. There's still some questions as to what can happen with that. But one of the recommendations and where this comes into play with PLEAC is, PLEAC was still PLEAC still had the necessary stuff under the law, but the question then became, what do we do for summary traffic violations? The most conservative approach on that is that we don't pursue for those types of violations because of the potential liability. But then we also have to weigh, the ability to be able to enforce traffic laws. And then we get into the question of when does it become a pursuit as to I'm trying to catch up to the vehicle to signal that the vehicle is going to be stopped. So there's a lot of policy considerations that your department in chief and your board has to decide in that, as an example, that just checking the box on the PLEAC standard isn't going to necessarily answer those questions, if that makes sense, Chris.
It does. It does. And I'm glad you brought up the police pursuit. Everybody should be taking a hard look at their pursuit policies in light of that Sowers case that we lived with for 4 years, involving a death and very serious injuries. Very terrible facts. Oftentimes lawyers will say bad facts make bad law. Frankly, I think the Third Circuit, I'm kind of hoping that decision, Andy, will be reviewed by the U.S. Supreme Court someday, but it really lowered the bar on cops. In that case, it was probably right, but I think that what the Third Circuit did, this is my professional view, nothing against the judges, but I think that they turned a federal claim into a tort claim. But that's for another matter. One more stickler thing about PLEAC. Over the years, we've seen this division between the governing body and the police department on internal affairs. So the person who asked the question about accreditation, I do take issue with a lot of those IA policies that I see as being sufficient in the eyes of PLEAC. They're not. I'm just going to say this right now, Andy. They're not, because they don't provide that connection and communication between the governing body and the police department regarding serious allegations of misconduct and neglect. They are still absent. So that is kind of a red flag there. Even though you're accredited, I take a hard look at your internal affairs policy to make sure that that proper bridge is built. Now we're running out of time. We probably want to get moving.
Yep.
All right.
Another question came in.
Oh, did we got another question?
Yeah, we have in 2015, this training was an entire day where a lot of these issues were drilled down and a booklet was handed out. Will this training occur again in the future? Joe, yeah, I think that's something that we can talk to PIRMA about doing. But you know, those are fun days. That's a good class that we can do. So we'll look into that with PIRMA and see if we can't get that put together. But great question. We do have a couple well, you know what? Let's just move on to Chris. This is your slide that you love. I'll let you take it.
I do. This gets my blood up. So the Violent Crime Control and Law Enforcement Act. What is that? That's the federal law that was enacted following the Rodney King beating in L.A. So if you weren't around then, that was when Los Angeles officers were actually convicted of crimes for using extreme excessive force against Rodney King with their nightsticks one evening. This resulted in the federal government. Now the federal government has jurisdiction to come into your local police department and investigate allegations of patterns of misconduct. We talked about in the very beginning of this program today, where if there is evidence of a pattern of civil rights violations, Merrick Garland and his investigators from the U.S. Department of Justice may have jurisdiction to come in, investigate you criminally, investigate you civilly, and actually implement very, very expensive changes to your police department. There's a police misconduct provision of this statute that gives them that authority. Have you ever heard of Ferguson? In that incident, that was about a 50-man police department. And when you had that use of force issue, you had the Department of Justice come in, investigate, and ultimately engage in what's called consent decrees that required that department to make many, many changes, very costly, very upsetting, and in our view, absolutely unnecessary, so long as you are taking the appropriate steps recommended today. All right, let's move on to the next. All right, Andy, you want to kind of get into the liability for money damages now?
Sure. So we'll kind of move through this pretty quick in our last few minutes that we have. And this is kind of where we take that litigator's look at why all this stuff that we've been talking about is so important. So, you know, we've talked about under federal law, we have Section 1983 of the United States Code. It was part of the Civil Rights Act of 1871, and I think it kind of puts it into play. It's known as the Ku Klux Klan Act. Basically, this was a civil remedy under federal law for individuals who were abused by law enforcement action, especially in the southern states, is the history on it. But it still proceeds today as a right of cause of action for any constitutional violations done by a municipal official, including a law enforcement officer, under the color of law. And that's what we just talked about there, is under the color of law. In other words, it's being done in their official capacity as a police officer. Sometimes where this gets a little interesting is when you have an officer who unfortunately commits a crime while employed. The question of color of law comes into play there that we can get into in the future if necessary. But just food for thought, so to speak. Timing of them. This is important. It's a 2-year statute of limitations. And the reason that that's important is because I implore you, chiefs of police and command staff, as well as municipal officials and solicitors, to please make sure that your departments are maintaining any type of evidence in a case where there could be potential civil litigation. When we talk, and I know this is hard to do because you can't save everything, but there are certain cases that we know about when they happen, that, you look at the other guy and go, yeah, that's going to result in a lawsuit. And those are the cases where we're asking that you please make sure that you maintain any type of body camera or MVR footage, any type of statements and things like that, because plaintiffs' attorneys, what they'll do is they will wait, 23 months and 29 days before they file that lawsuit to get there. And then when we go in, it's like, oh, well, we had this, we had this, we had this. Okay, well, where is it? Well, it got destroyed because it's outside of our retention schedule. So again, that may be something that you need to take a look at. Respondent superior, we can skip over that for right now. Qualified immunity, real quickly, is the theory that you can't violate a constitutional right unless it is clearly established. Qualified immunity over the last year and a half to 2 years has kind of gotten a bad rap. There's been questions of, we're going to do away with qualified immunity for law enforcement. There's actually no statute that provides qualified immunity. This is a theory that has come out of a judicial interpretation, and it makes sense. Is how can you violate somebody's rights if you don't know that it was clearly established that they had that right? So this is a way that it provides law enforcement officers, with an out to escape liability. I will tell you that depending on the courts, there are courts who are very hesitant to apply this, especially early on in the game. So don't just think to yourself, oh, I've got qualified immunity, never mind. You still may need to have to go through the lawsuit and up into including the trial in order to even get this type of qualified immunity to protect you or shield you from constitutional remedies. Chris, why don't you take our police management checklist?
Sure. Sure.
You like to talk about this, and you can lead us home.
Yeah. So consistent with our recommendations in the beginning, don't throw out your PowerPoint. Print it out, use it as a guide, make copies of it, share it with your elected officials, share it with your chief, share it with your solicitor so that you can schedule that meeting to go through it. And I'm not going to read everything on these slides, Andy, because we are running out of time. But obviously updating the standard operating procedures as we have recommended on those high-risk critical tasks. Are you maintaining the record of discipline? How is your department communicating with each other? All kidding aside, I continue to think that issuing important policies and important directives should be on paper. I am not a proponent of handing out a jump drive, flash drive, or CD-ROM for police officers to look at it later. Look, it's been my experience. They're not doing it. I think that they should be required to maintain a 3-ring binder of all of the relevant policies for easy reference in about 2 seconds. I know some of my colleagues disagree with me on that, but I think it's good practice to have it at the ready so that they can review it. I've seen too many.
Let me jump in real quick on that, yeah, Chris. Please,
Andy,
I don't care how you do it. I know now that there are database policies that will allow you to send out it electronically. The most important thing on it, though, is just however you decide to do it, make sure that there is a way that will track and show that the officer received the policy and was aware and read the policy. That's the most important thing that we need to go with. I see we had a quick question. Should PDs have a reckoning period based upon your recommendations for maintaining records of discipline? So reckoning periods is one of those things that, as Chris knows, I don't get it. And this is where I think that there is a little bit of confusion. For me, and Chris, correct me if I'm wrong, a reckoning period, the only thing that reckoning period does is it just says that we can't use this against you in the future for purposes of disciplinary action if it's outside of whatever that reckoning period is. That doesn't mean that it automatically disappears into space once the reckoning period gets hit. So my suggestion to that would be is that you can have reckoning periods, but just because you have a reckoning period doesn't mean that it removes it from your record. And I think that that's especially important now, given the requirements under Act 57.
I totally agree with you, Andy. And I would
Wow, that's the
suggest
first
that,
time. Wow.
I know,
Somebody
right?
mark
Well,
that down.
let me go a little further. Thank God this is not offering legal advice because I'm probably going to get people in trouble. But I've seen some collective bargaining agreements that require the destruction of that disciplinary paper from a file. My clients aren't going to do that. I'm not destroying any records, by the way. They are not going away into space. They will be kept, and I'm going to steal your term. I love this, in the gone but not forgotten file. All right.
Well, I
So
think
that's,
Act 57 has done away with the gone but not forgotten file now. So that's a good thing. We talked about number 4, making sure that we have a way of tracking that the officers have acknowledged policies and procedures that come out and that they read and understand them. A lot of that's done now electronically through the electronic system, but we just need to make sure that we have a way of doing that. Are we out here? Chris, harassment policy, go ahead, hit that.
yeah,
real
that's
quick.
a given. Just 30 seconds real quick. Managers, if you're on here, elected officials, everybody that's on this, our recommendation on harassment in the workplace, there ought to be one harassment policy that is government wide, that is municipal wide. There's no need, and it's just antiquated to have a harassment policy in the police department and another harassment policy that deals with non-uniform employees. It's nuts. It creates confusion. There shouldn't be 2 separate schemes. There ought to be one, and that's another whole seminar, and I'd be happy to talk to you about it later, but you should have one harassment policy municipality-wide. And you shouldn't have the chief investigate those either. That should be someone else. Job descriptions, absolutely crazy about that. Every single rank, every single position ought to have a written job description. You want to make sure you're maintaining your training records. Performance evaluations are non-existent in Pennsylvania. I see very few police departments doing it. You got to do it, at least on an annual basis. It's absolutely necessary. Personnel files, actually, that's one thing Pennsylvania does have a statute on, and that is what goes in a personnel file and what doesn't. We have some primers on that we wouldn't mind sharing with you if you send us an email that talks about how you do that. How to handle internal affairs files. Long story short, an internal affairs file is not a personnel file. That is to be kept secured and confidential. And then again, I said this 1,000 times. Andy and I have said this to you. Meet with your board managers, liaisons, to inform them that you've taken these measures, and to meet with them to make sure that they understand how the process works. We'd be happy to help you going forward, as always. Andy, I'll turn it over to you for the last word.
Yep, thanks. Just real quick on the IA files. One of the things, chiefs and command staff, if you haven't done yet, you might want to take a look at is come up with a plan as to how you are going to respond to Act 57 requests for employment information from other police departments. What's going to go, what's not going to go. It's probably easier to come up with it now rather than the one that you need to respond to in the heat of the moment. So just something to put on your radar screens if you haven't. Here is our information. Please feel free to reach out to us with any questions that you may have. Thank you so much for your participation in the program. We hope that you enjoyed it. Reach out to us with any questions and be safe. Thanks.
Thank you, Chris and Andy. We had a great turnout today, and I think you provided so much information that we do need to consider making this an all-day program, whether it's virtual or in person. We'll have to have that discussion. So everyone, please join us next month on March 21st, where we will have a rerun of workplace investigations. And I think it's you guys are up again for that, right?
I think so, yes.
So you'll see these guys again next month. Again, it's a rerun, but please join us on March 21st. In the meantime, have a great day.
Stay out of trouble.
Thank you, everyone.
All right. Thank you, Kim.
Thanks, everybody.
Thank you, Andy.
Yep.